start or should we wait for 1 or 2 minutes?
Ma'am, we'll wait for participants have already started joining, ma'am. We should start, I think.
Right now?
Yes, ma'am.
I'll just ask Justice Sir. Sir, the participants are joining. Should we start or should we wait for 1 or 2 minutes? Should we start, sir?
Yes, please.
Yes, thank you, sir. Thank you. Thank you.
A very good morning.
Yeah, please.
Yes, ma'am. You wanted to say something?
No, please start.
Okay. A very good morning to one and all present. Very good morning to you, sir. A very good morning to all the attendees and all the lecturers and my colleagues. It's a very warm welcome to all. We are here together for a very special occasion to discuss a very important issue regarding the constitutional rights and the situation that we are suffering, situation that we are in this pandemic. And to enlighten us and to educate us on this topic, today among us we have Honorable Justice Rajsekhar Mantha, sir. And I would like our Honorable Director, ma'am, to say a few words and invite the guest speaker to the dais. Ma'am.
Thank you, Vardhaman. And in fact, a warm welcome to all the members present here, and especially our Honorable Justice Sri Rajsekhar Mantha Garu, who is now a sitting judge of Calcutta High Court. And we are really privileged to have Honorable Justice here to give his opinion and knowledge on this most important dynamic topic, contemporary topic of the day. Because we are all facing, this is what I feel is highly contemporary and everybody is interested to hear, because what exactly the rights do we have in this, in the constitution, in the democratic country like India. So to begin with, I think I just would like to say a few words about Justice Rajsekhar Mantha, sir. So has his education at Calcutta from St. Paul's Boarding and Day School, and also college education from St. Xavier. And sir has did his undergraduate law LLB from the University of Law, Nagpur. Then also he did his LLM post-graduation in law from King's College, UK. So that shows that the strength of our guest here. In fact, he has a voracious and a very, very, a good motor in his college days. That's what we have came to know from his backdrop. And, he participated many number of, guest lectures, and he is the resource person for most of the national law universities. So sir is associated, and in fact, he visited our law school way back in October last time to give a good lecture to the freshers on the advocacy skills. And is also continuously in touch with our GITAM School of Law, and has facilitated us to send some of the students to the Calcutta High Court for internships. Thank you very much, sir, for continuing support of yours. And the children are really enjoying their association and their learnings from you. In fact, to start with this particular webinar, or like the seminar we have on the web link, I would like to recall one statement made by Martin Luther King way back in 1966, when there was a convention on of the medical committee on the human rights. He talks about that, of all the inequalities that are existing in this globe, injustice is, it is a great injustice to the healthcare, which is shocking and inhuman. See, really, way back he mentioned in 1966, that is the inequalities in providing healthcare, getting the healthcare is the most inhuman thing, and it is really shocking. So of course, the health system in India is not really that robust and that healthy. I'm not talking about the getting of good treatment or the good expertise over the particular disease or the treatment. I'm talking about the economies and the policies that we are having in this country. Because what happens is we are not having, we are neither sticking to this particular proper business model where we can really encourage hi-fi, corporates so that we get the best of the delivery systems, or now we are not even concentrating on the low cost, effective system which can really give access to this particular medical care to most of these people who are in the below poverty line. So we are neither this nor that, and we have experienced the same scenario in this pandemic, because what happened is the GDP we are now contributing towards healthcare is 1.29, very, very, very low comparing with other countries. Of course, is almost equivalent to very, very of those countries where they are considered to be very, underdeveloped. So that way we have to see that a time is now right to think about, to propose that the healthcare should be a fundamental right in the Indian Constitution. And of course, the judiciary with the active, judges have given wonderful judgments right from 1995 with the judgment of, like Consumer Education and Research versus Union of India. And also in 2018, we have seen Navtej Singh Johar versus Union of India. They have given, it is like a constitutional, a derivative. It is not basically imbibed in the constitution, but through the judgments, they have pronounced that healthcare is forming a part and parcel of Article 21, right to life. So that's where we have to really work out that at what are we right now in a stage, the country is right now in a stage to proclaim, to give this as a status of one of the most important fundamental right. Of course, there are certain guidelines that are given in the directive principles of state policy, but these guidelines, of course, we have to keep on evaluating and achieving, but making it as a fundamental right is the order of the day. Now, of course, in the 2019, the Niti Aayog report has acknowledged that India had an unequal public health system. It has made it very clear that India has this unequal public health system, and also proposed a committee that, like a high-level committee in the 15th, I think, Finance Commission, that, like recommended that it should be declared as, fundamental right. Now, in addition to the statutory recognitions, of course, we have the policy of the framework. How do we really put it? Once it is declared in the policy, how do you put it? Like execution is very, very important. I think the principles of solidarity, proportionality, and transparency would definitely will give us some clue for implementing these policies. Then also I would like to state, like, a stark inequality, especially we have seen in the marginalized groups recently, who are actually been, especially I'm focusing about the migrant labor who have been crossing their borders, coming here for earning and going back. So these people, during their transit, some of them affected with this pandemic, and absolutely, I don't think any satisfied, help has been really extended to them. In planning from the recovery of this pandemic, we need more just and equitable, principles. Just and equitable principles, which ensures all people, irrespective of their creed, have this accessibility, and also irrespective of the caste, creed, sex, people should be able to reach this particular, privilege of having or being healthy. As members of the legal fraternity, we also have a particular, a specific role to play here. We need not be always the, advocates for challenging the health policies, but we can always say it loud that yes, this is the gap we are having, and we need to really fill it up. And of course, I would like to say that, once this particular option is given, start promoting this, we will definitely reach the the pinnacle, and every person in this country will at least get access to health and well-being also. So with this particular backdrop, I'm sure we should be the one person who can always say, let there be no child somewhere die in every 3 seconds for the lack of this healthcare. Or let us be one where we can say that the birth of a person should not determine the right to life. definitely it should be forming as a basic right. It is not a privilege given by the Constitution. It should be a matter of right for each and every person who is, imbibing the philosophy of democracy in this country. So with this small brief account, and we requested Honorable Justice Rajsekhar Mantha, so to give us some brief, because how the courts are really viewing it, and in fact by elaborating the concept of the horizons of Article 21 and trying to fix up the basic right of health into it. Of course, it has been achieving a lot. The Honorable Supreme Court is achieving a lot, but we all should really echo and voice about to make it as a fundamental right in this country. So with this backdrop, I invite our Honorable Justice to give his lecture on this particular aspect, because a lot of students are there, sir, in this particular webinar who love to hear your voice. And also there are many doctors, because they also should know what exactly the constitutionality and constitution principles. And in fact, as a social responsibility, I would like to add one line here. The GITAM University is really contributing a lot, because our university, the medical sciences, GITAM Institute of Medical Sciences, has been made as a district COVID center, and our doctors are working throughout the day, 24/7, sir, with all the legal and paralegal forces, and it has earned huge appreciation from the society. So as a school of law, I am sure our students also should have this particular policy, should really work out and really echo their voice for, right to health is a basic right for the human existence. And with this small note, sir, I would like to invite you and, leave the podium for you to have your discussion. Thank you, sir. Heartily welcome, sir, once again.
A very good morning to everybody. I must first thank Mrs. Anita Rao for the kind words of introduction. I would also equally like to start by congratulating the doctors at GITAM University Medical College and the doctors who are working tirelessly day and night across the country and across the world. Not just doctors, but all healthcare workers and support staff, nursing. You are the beacon of light for humanity today. With these few words of thanks, I'd like to take on the topic. We will look at the healthcare rights in India, not just from a pandemic point of view. The issue has assumed importance in view of the pandemic, but the healthcare infrastructure, healthcare regime in the country now and has always needed a very, very serious rethink from all perspectives, and we shall be addressing it today from a legal standpoint. In fact, Mrs. Anita Rao has summed up in one form a conclusion which I'd be sharing, that healthcare, the right to health and right to medical facilities must be deemed and recognized as a fundamental right. In fact, when I was thinking of addressing and preparing for it, I wanted to read out my conclusion first and then take you to the reasons therefore. But since Mrs. Anita Rao has very succinctly put the conclusion across, I shall straight away take you to what are the issues that I felt necessary to be addressed. The COVID-19 pandemic has opened the eyes of the entire world for the need to establish effective healthcare facilities, not only to address pandemics, but also overall them to meet the growing and new challenges of times. India and nations across the world have seen the consequences of failure to put in place a strong and effective healthcare framework. Research institutions across the world are racing in their search for a preventive vaccine for the coronavirus and for an effective way of treating the infected. The most vulnerable of all have been those who have existing ailments. And it is here that the need for looking at healthcare from a rights point of view must be examined. The Indian Constitution provides for a framework for a welfare socialist pattern of development. While civil and political rights are enshrined as fundamental rights that are justiciable, social and economic rights, however, like health, education, livelihood are provided for as responsibilities for the state in the form of directive principles for governance and hence not necessarily justiciable. The latter comes under the domain of planned development, which the state steers through 5-year plans and other development policy initiatives. The development paradigm adopted by the state had a social dimension that, with a need to support private sector growth. To take 2 examples, while private pharmaceutical industry got a lot of subsidy and support for its growth, drug price control helped in keeping the prices of medicines on leash. The increase in the number of doctors contributed largely to the development of private healthcare. The government only developed a limited healthcare regime through a primary healthcare system in rural areas and district and town hospitals and dispensaries in urban areas. However, the development approach was never rights-based, and hence the limited entitlements that were available for different development programs, including the healthcare, had a limited impact. The contribution of the 5-year plans to social sectors has been abysmally poor. Mrs. Anita Rao was referring to this in her introduction. Let us first look at the international perspective and the covenants that are there right from the establishment of the United Nations. The World Health Organization defines health as a state of complete mental, physical, and social well-being, not just the absence of any disease or infirmity. It further says that the development of health is necessary for a country for overall peace and security. The enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being, irrespective of race, religion, political belief, economic or social condition. It says that without development of health in a country, prosperity cannot be achieved. The dangerous spread of contagious diseases haunts governments of nations. Proper awareness of hygiene and sanitation are crucial for robust health. The state plays a very key role in this regard. Imagine a situation where there is enough development in the world, the economy is developed, there is prosperity, economic prosperity, but if the common populace is unhealthy, ridden with ailments and illnesses, what is the use of all this development is a question that I will ask. India joined the United Nations on the 30th of October 1945. And on 12th of December 1948, the Universal Declaration of Human Rights was proclaimed. India was a party. The framing of the Indian Constitution was influenced by the UNHDR as evident from the fundamental rights and the directive principles of state policy. Most of the civil and political rights are guaranteed under the Indian Constitution as fundamental rights, but economic and physical rights do not have such guarantees. The Constitution makes a forceful appeal to the state through the directive principles to work towards assuring these rights through the process of governance, but clearly states that the courts cannot enforce these same. Under Article 12(1) of the Protocol on Economic and Social Cultural Rights, states and parties have agreed, states meaning countries across the world, have agreed to recognize the right of enjoyment of highest attainable standard of physical and mental health. Article 12(2) provides that the steps to achieve the full realization of this right. At 12(2)(b), the creation of conditions which assure to all medical service and medical attention, even in the event of sickness. Nobel laureate Dr. Amartya Sen has named illiteracy, malnutrition, and lack of health care as the three unfreedoms in developing countries. On 18th April 2000, at Geneva, addressing the International Coordinating Committee on National Institutions and Human Rights, he said, national human rights institutions have the full range of human rights in the remit. An area which we have not touched on and which I would like to mention here for further consideration is the right of health. Weakness in the delivery of proper health care indicates failure of the state. Recently, in 2006, the Convention of Rights of a Person with Disabilities has mandated that persons with disabilities have complete right to enjoyment of the highest standard of health. In terms of Article 17 of the Beijing Conference in 1995, Articles 11, 12, and 14 of the Convention, all forms of discrimination against women and were condemned and were mandated to be abolished in each member state country. Article 12.1 of the Protocol on Economic and Social and Cultural Rights, all member states have agreed to address the need for the right to health as a basic right. On the question of justiciability of international covenants, how far are these international covenants justiciable in municipal law and domestic law and Indian law? Like Britain, India follows the principle of dualism. This means that for the international codes to be applicable in India, there is need for separate parliamentary legislation. Since only some of the international human rights treaties have been incorporated or transformed into domestic and municipal laws in India, they have only an evocative significance and may be used in courts, by courts, or the litigants to derive inspiration therefrom. Many of these human rights treaties ratified in India have been used by Indian courts in the context of fundamental rights, particularly Article 21, as an omnibus umbrella, which we shall examine at a later stage. Let us now come to the constitutional experience in India. The Constitution of India has left the responsibility of the right to health to the executive branch of the government. This means that it is up to the will and wisdom of the central and state executive to look after the health of its citizens and ensure timely availability of medical facilities. The National Health Policy was first formulated by the government in the year 1983 and then subsequently revised in the year 2002 and lastly in 2017. Experts, however, feel that there has not been any significant change in the National Health Policy. The fulfillment of the goal of physical and mental well-being of the people has been painfully slow and lacking. The right to health is not ordained as a fundamental right in the Constitution. It has been mentioned several times in the directive principles of state policy under Part 4 of the Constitution and in subsequent articles of the Constitution. Article 38, for example, says the state will secure social order for the promotion of the welfare of the people. Providing affordable health care is one of the prominent ways of promoting welfare, according to me. Article 39E calls for this upon the state to ensure that health as well as strength of workers, men, women, and the children of tender age are not abused or left or ignored. Article 41 imposes a duty on the state to provide public assistance in case of unemployment, old age, sickness, and disablement. Article 42 makes provision for a benefit of the child and the mother for maternity benefits. Article 47 makes it the duty of the state to improve public health, securing of justice, humane conditions of work. An extension of sickness, old age disbursement, and maternity benefits are also contemplated. Further, state's duty in this regard should include the prohibition and consumption of inappropriate substances which are injurious to health. Article 48A mandates that the state shall endeavor to protect environment and safeguarding of forests and wildlife, protection of environment is now understood as protection of health. Apart from these directive principles of state policy, some other provisions relating to health have been included in the 11th schedule and the 12th schedule of the Constitution, where the Gram Panchayats and municipalities are required to ensure healthy, potable drinking water and sanitation for citizens, to keep in mind the health, welfare of family and child development. Article 243G lays down that the legislature of the state may endow the panchayats with necessary powers and authority in relation to matters listed in the 11th schedule. The entries in the 11th schedule have a direct relevance to health in the following manner: health and sanitation, including hospitals, primary health centers and dispensaries; social welfare of handicapped and mentally retarded persons. This has been passed on to the municipalities and the panchayats in the country. And in fact, in each panchayat and rural area, there are primary health centers to cater to one or more than one panchayat. And in the municipalities, there are hospitals set up by the government. But the question really is, are these all enough? Whereas Article 243W finds place in Part 9A of the Constitution, imposes a responsibility to the municipalities to ensure, amongst other things, public health, sanitation, conservancy, and solid waste management, as mentioned in this 12th schedule. These are general principles of health and cleanliness and sanitation that the municipalities and panchayats are required to maintain. But where has this taken us in the 70 odd years post the Constitution? The healthcare system in the country has always been wanting, and let us therefore now look at how the Supreme Court has dealt with issues regarding healthcare and medical rights and medical facilities in its decisions. The first of the decisions I want to refer to is the Paschim Bongo Khet Mazdoor Samiti versus State of West Bengal. This is reported in 1996, Volume 4, Supreme Court Cases, page 37. At paragraph 9, the Supreme Court says this: the Constitution envisages the establishment of a welfare state at the federal level as well as at the state level. In a welfare state, the primary duty of the government is to secure the welfare of people. Providing adequate medical facilities for the people is an essential part of the obligations undertaken by the government in a welfare state. The government discharges its obligation by running hospital, health centers which provide for medical care to a person seeking to avail those facilities. Article 21 imposes an obligation on the state to safeguard the right of life of every person. Preservation of human life is thus of paramount importance. The government hospitals run by the state and the medical officers employed therein are duty bound to extend medical assistance for preserving human life. Failure on the part of the government hospital to provide timely medical treatment to a person in need of such treatment results in the violation of the right to life guaranteed under Article 21. In the present case, there was a breach of the said right of one Hakim Sheikh, guaranteed under Article 21, when he was denied treatment at various government hospitals, which were approached even though his condition was very serious and he was in need for medical attention, and that too immediate. Since the said denial of the right of Hakim Sheikh guaranteed under Article 21 by officers of the state and officers of the state in the hospitals run by the state cannot avoid the responsibility of denial of the constitutional right of Hakim Sheikh. The next decision that I wish to cite is the case of Pandit Paramananda Katara versus Union of India, reported in 1989, Volume 4, Supreme Court Cases, page 286. If you see from the earlier decision, that is the Paschim Bongo decision, the Supreme Court was looking at the right to health to come within the umbrella of Article 21, which is the right to life, which is a fundamental right. We will see from the other decisions how the Supreme Court had to repeatedly resort to Article 21 for this. And then we will take it further towards our destination and conclusion that we will propose to arrive at. At paragraph 7 in the Paramananda Katara decision, the Supreme Court said, there can be no second opinion that preservation of human life is of paramount importance. That is so on account of the fact that once life is lost, the status quo ante cannot be restored, as resurrection is beyond the capacity of man. The patient, whether he be an innocent person or a criminal liable to punishment under the laws of society, it is the obligation of those who are in charge of the health of the community to preserve life so that the innocent may be protected and the guilty may be punished. Social laws do not contemplate death by negligence, and the same may tantamount to calling for a punishment. Article 21 of the Constitution of India casts obligation on the state to preserve life. The provision, as explained by this court in scores of decisions, has emphasized and reiterated gradual emphasis on the need for health. A doctor at the government hospital positioned to meet the state obligation is therefore duty bound to extend medical assistance for preserving life. Every doctor, whether at a government hospital or otherwise, has the professional obligation to extend his services with due expertise for protecting life. No law or state action can intervene to avoid or delay the discharge of the paramount obligation cast upon the members of the medical profession. The obligation being total, absolute, and paramount, laws of procedure, whether in statutes or otherwise, which would interfere with the discharge of this obligation, cannot be sustained and must therefore give way to the right to life, and hence the right to treatment, medical treatment. In the next case, which is Ram Lubaya Bagga versus State of Punjab, reported in 1998, volume 4, Supreme Court cases, page 117. It was held as follows at paragraph 26. When we speak about a right, it correlates to a duty upon another individual, employer, government, or authority. In other words, the right of one is an obligation of another. Hence, the right of a citizen to live under Article 21 casts an obligation on the state. This obligation is further reinforced under Article 47. You see here, the Supreme Court was balancing the right to life under Article 21, which is an enforceable, justiciable, and a fundamental right, with that of Article 47, which is under Part 4 of the Directive Principles of State Policy, to achieve and bring this right of medical and healthcare need for the common citizen under a fundamental right under Article 21. This is an attempt by the Supreme Court to emphasize the need for medical facilities. This emphasis and the regular attempt by the Supreme Court and the High Courts to bring the right to medical facilities under Article 21 must therefore be seriously addressed. Why should the right to medical facilities not come in or arise or exist as a comprehensive standalone fundamental right is what we will be stressing in course of this discussion. The Supreme Court goes on in Ram Lubaya Bagga to say, this obligation is further reinforced in Article 47. It is for the state to secure health to its citizens as its primary duty. No doubt the government is rendering this obligation by opening government hospitals, health centers, but in order to make it meaningful, it has to be within the reach of people as far as possible. to reduce queues of waiting lists, and it has to provide all facilities which the employee looks at for in another hospital. This is in the context of an employment and the right of an employee for medical facilities. But it is very relevant, these statements, for the purpose of our larger objects that we seek to address in course of this webinar. Its upkeep, maintenance, and cleanliness has to be beyond aspersion. That is the upkeep of the hospital and the medical facility. To employ the best of talents and tone up its administration to give effective contribution. Also bring in awareness in welfare of hospital staff for their dedicated service. Give them periodical medico-ethical and service-oriented training, not only at the entry point, but also during the whole tenure of their service. Since it is one of the most sacrosanct and valuable rights of the citizen and a sacred obligation of the state. Every citizen of this welfare state looks towards the state for it to perform its obligation with top priority, including by way of allocation of sufficient funds. This in turn will not only secure the rights of its citizen to the best of their satisfaction, but in turn will benefit the state in achieving its social, political, and economic goals. For every return, there has to be an investment. Investment needs resources and finances. So even to protect the sacrosanct right, finances are an inherent requirement. Harnessing such resources needs top priority. This is a indication by the Supreme Court to the government in its small attempt at a guidance for the government. In the case of Surjit Singh versus State of Punjab, reported in 1996, Volume 2 Supreme Court Cases, page 336, it was observed as follows. It is otherwise important to bear in mind that the self-preservation of one's life is the necessary concomitant. Is the necessary concomitant of the right to life enshrined in Article 21 of the Constitution of India. Fundamental in nature, sacred, precious, and inviolable. The importance and validity of the duty and right of self-preservation as a species in the right of self-defense in criminal law. Centuries ago, thinkers of the great land conceived of the right and recognized it. In the case of Vincent Panikurulangara versus Union of India, reported in 1987, Volume 2 Supreme Court Cases, page 165, it was observed as follows. Maintenance and improvement of public health have to rank high as these are indispensable to the very existence of the community, and betterment of these depends on the building of the society which the Constitution of India envisages. Attending to public health, in our opinion, is therefore high priority, perhaps one at the top. The importance of this judgment could be seen in the light of the recent international agreement on TRIPS. Justice Ranganath Mishra's observations regarding the right of health vis-a-vis the right of life in the instant cases was as follows. Article 21 of the Constitution guarantees right to life, and this court has interpreted the guarantee to cover a life with normal amenities, assuring good living, which includes medical attention, life free from diseases, and longevity up to normal expectations. The Supreme Court has also brought occupational hazards to workers within the coverage of Article 21. The right to health and medical care to protect health and vigor of worker while in service or post-retirement has been held to be a fundamental right under Article 21. Read with the directive principles of state policy, that is Article 39E, 41, 43, and 47, which I had read out slightly earlier. And all fundamental human rights to make life of workers meaningful and purposeful so that human dignity can be achieved. In Rakesh Chandra versus State of Bihar, reported in 1989, Supplement 1, Supreme Court cases, page 644. A letter by two citizens of Patna regarding the conditions of a mental hospital near Ranchi was treated as a public interest litigation and was admitted under Article 32. On a visit of the Chief Judicial Magistrate and a report submitted therefore to the Supreme Court, it was found that there was acute shortage of water, improper sanitation, unhygienic environment, non-availability of light, less number of beds, no doors in the wards, improper bedding clothes, and improper diet for the inmates. There was no account of the stock of medicines, etc. Despite orders by the court, the defects were not being remedied. The court was of the view that it was difficult for the court to monitor the management of the hospital, and a committee of management was constituted with full powers to look into these matters that the Supreme Court felt were very, very vital and coming under the umbrella of Article 21, which is the right to life. The next decision is the case of Common Cause versus Union of India, reported in 1996, Volume 1, Supreme Court Cases, page 753. This was a public interest litigation in which the petitioners had highlighted serious deficiencies and shortcomings in the matter of collection, storage and supply of blood through various blood centers, that is the blood banks, operating in the country. It was found that there was a number of deficiencies such as no medical checkup of blood sellers, including blood donors and sellers, because some of whom turned out to be alcoholics and drug addicts and were living in unhygienic conditions. The blood was stored in unhygienic conditions, and there was no proper medical personnel available for storing or manning these blood banks. The Supreme Court appointed again a committee to examine the matters and give certain directions, such as for the setting up of a national council for blood transfusion and state councils, and the activities would cover the entire range of services relating to operation and requirement of blood banks. This included the launching of effective motivational programs to utilization of all media for stimulating voluntary blood donations, launching programs at education institutions amongst the labor industry, the trade, training, and the personnel relating personnel who are operating and manning these blood banks. The court has not only recognized the importance of maintaining hygienic conditions within hospitals, but also cleanliness that has to be maintained in hospital surroundings, and upheld the removal of certain risks within the hospital premises which posed health hazards. In the case of A.S. Mittal versus State of Uttar Pradesh, reported in 1989, Volume 3, Supreme Court Cases, page 223, the Supreme Court ordered the state government of Uttar Pradesh to pay compensation as it had not followed the norms prescribed for eye camp, eye donation camp, and eye checkup camp, and had caused serious injuries to 84 patients. In N.D. Jayal versus Union of India, before I come to this, what I would like to emphasize is in each of the decisions that have been cited and are otherwise available on public domain, i.e. decisions of the Supreme Court, the power of the Supreme Court under Article 141 was exercised. Under Article 142 was also, in fact, 142 was exercised, which power is not there with the High Courts under Article 226 or 227. What the Supreme Court can do under Article 142, no other court in this country can do. And hence, we shall also look at the need for a fundamental right for healthcare and medical facilities from that standpoint. In N.D. Jayal, Union of India, reported in 2004, Volume 9, Supreme Court Cases, page 362, it was stated that the right of Right to health is a fundamental right under Article 21. Protection of this right is inextricably linked with clean and healthy environment, and medical facility is therefore a fundamental right. It is therefore seen that health and cleanliness, right to clean water, clean hospitals, hygiene, good hygienic working conditions, physical and mental well-being of workers in workplace have all been held to be rights under Article 21 of the Constitution of India by the Supreme Court in its various decisions. These steps taken by the government till now, the existing healthcare framework, this is what we shall address now. The national health policy has been regulating health issues in India. The stated object of the policy is to nationalize the health sector to ensure that everybody has access to basic health facilities, employ more people for the development of the health sector, make access to medical technology and medical facility to every citizen, to develop better medical facilities, especially the deprived class, and prevention of diseases, and promote good health. Experts, however, feel that the existing health facilities and policies of the state are not contributing effectively to the health of people at large. The principal reasons being that rapid technological advancement in general healthcare services and non-permeation of these benefits to the poor and the marginalized, even for that matter, the middle class of this country. In 2002, under the health policy, healthcare expenditure was kept at 2% of the GDP, and the target for 2025 has been kept at 2.5%. A 0.5% increase in the total GDP contribution to medical and healthcare facilities is negligible and inadequate, according to me, for the improvement of health in India. This is all the more shocking in the context of the recommendation of the World Health Organization, which has suggested that the standard healthcare expenditure should be 5% of the GDP of the country. For India, since there is already an infrastructure, albeit ramshackle, there is need for an initial one-time investment of at least 10% of the GDP in overhauling the existing infrastructure, developing new and sustainable healthcare facilities for the future, inter alia to deal with pandemics and life challenges in the present and in the future. One is reminded of the Obamacare health plan mooted by a former president of the United States, with Barack Obama, which inter alia also aimed to put in place a preparatory war plan to deal with pandemics. It is also necessary in this context to look at the National Health Service facility in the United Kingdom, which makes elementary medical needs, that is going to a physician for a small ailment or illness, to all the way to a major surgery, which is 100% and absolutely free for all lawful and long-term residents, which include citizens and also long-term students studying in the United States and United Kingdom and working there. This is a model that we could adopt in India. If one looks at the distribution of healthcare resources across regions, rural and urban, one sees disparity. In metropolitan areas, public health budgets range from rupees 500 to 1300 per capita, in sharp contrast to public health areas, that is the rural areas, where it is only 40 to rupees 120 per capita. Urban areas across the countries have a bed population ratio of 300 beds per 1 lakh, and the population, in contrast to in the rural areas, is 40 beds to 1 lakh persons. There is therefore gross inequality, but there is no law to force this right, to force the government to do something, or enforce this right of healthcare, at least if not achieve 100%, one bed for 1 lakh, one bed each for every person, let us at least try to achieve 80%. To sum up from the earlier section, healthcare infrastructure, including availability of doctors and medication, is grossly inadequate. Then there are pre-existing underlying conditions of health and access issues that need to be factored in, which are equally important from a rights perspective. This is becoming all the more relevant in the present pandemic situation, where not only would a person exposed to COVID be vulnerable, although substantially well treatable, but people with existing ailments like heart diseases, diabetes, existing lung infections are in a more precarious situation. So in this regard, pre-existing health conditions are important, and a decent national healthcare policy would address all these issues. Given the high degree of poverty and the low level of public sector participation, expecting the state agencies to fully respect, protect, and fulfill the healthcare requirements of people completely is thus very remote from the existing public infrastructure or public sector participation in healthcare. Another concern in this regard is the economic accessibility. Large-scale poverty and predominance of private sector in healthcare coexist. This contradiction reflects the state's failure to respect, protect, and fulfill its obligations. Data shows that out-of-pocket expenses account for 4% of the GDP, as against only 0.9% of the GDP expended by the state agencies. The poorer classes contribute to disproportionately higher amount of incomes to access healthcare services, both in the private sector and in the public sector. Further, better off classes use public hospitals in much larger numbers, with their hospitalization rate being 6 times higher than the poorer classes. As a consequence, they consume an estimated amount of over 3 times of public hospital resources than the poor people. All international treaties and doctrines and covenants talk about affordability, but do not stress on the need for free health services. Given the poverty levels across the world, this notion is questionable as far as provisions for social security like health, education, and housing. Free services are viewed negatively in the global debate, especially since we have a unipolar world. It is deemed to be disrespectful to individual responsibility with regard to the healthcare. For instance, in India, there is greater pressure on public health systems to introduce or enhance user fees in the belief that they will enhance responsibility of public health system and make it more efficient, which, according to me, is a misnomer. In many states that have adopted such policy, the immediate adverse impacts are seen, the most prominent being decline in utilization of public services by the poorest. The 10th 5-year plan draft document supports raising more resources by increasing user charges in secondary and tertiary hospitals. Finally, there are issues pertaining to acceptability and quality. The state is found seriously wanting in this regard. There is clear rural-urban dichotomy in health policy, with urban areas enjoying comprehensive healthcare services through public hospitals and dispensaries, now preventive inputs, and in contrast to rural areas where poor curative services exist even today. This violates the principle of non-discrimination and equality under Article 14 of the Constitution of India, and is a serious legal and constitutional and ethical concern. This has to be addressed. Medical practice, especially private, suffers from some want of ethics. I will not say all private medical facilities are unethical. There are very sincere private medical facilities available. In fact, the present pandemic has shown that some private organizations and hospitals have gone bent backwards to give help to COVID patients and also other healthcare, health requirements of the public at large. but it's equally true that there are some private hospitals and private healthcare services that have completely shirked their responsibilities. One cannot blame the private healthcare industry completely, because after all there is a private investment there, and investment and business and charity do not go hand in hand. There are issues of medical malpractice and other things that have regularly cropped up before the High Courts and the Supreme Court, and the Supreme Court and the High Courts have stressed the need for an appropriate due diligence in their work by doctors and other healthcare professionals in various decisions. Despite the existing medical facilities in both rural and urban areas, the distribution of the same, again, is quite poor. Enforcement of these duties against the state remains a mere hope. In fact, most of the decisions of the Supreme Court and the High Courts relating to health and working conditions at workplace, workers' rights to healthcare, environmental health, have been decided, as I said already, only under the umbrella, the omnibus article, that is Article 21. Some High Courts have even refused to enforce the right to health because it is not a fundamental right. Let us therefore now look at the next section, which deals with the need of the hour. The right to health in all its forms and at all levels contains the following interrelated and essential elements, the precise application of which will depend on the conditions prevailing in a particular state party. This is a mandate from the international covenants. First thing is the availability of these facilities. Functioning public health and healthcare facilities, goods and services, as well as programs have to be available in sufficient quality with the state party. The precise nature of the facilities, goods and services will vary depending on the numerous factors, including the development levels of the state. They will include, however, the underlying determinants of health, such as safe and potable drinking water and inadequate sanitation facilities, hospitals, clinics, and other health-related buildings, trained medical and professional personnel receiving domestically competitive salaries, and essential drugs as defined by the World Health Organization Action Program on Essential Drugs. Second is the issue of accessibility. Health facilities, goods and services have to be accessible to everyone without discrimination within the jurisdiction of the state party. Accessibility has four overlapping dimensions. Non-discrimination. Health facilities and good services must be accessible to all, especially the vulnerable and marginalized sections of the population, in law and in fact without discrimination on any prohibited grounds. Then there is a question of physical accessibility. Health facilities, goods and services must be within the safe physical reach of all sections of the population, especially the vulnerable or the marginalized, again, such as ethnic minorities, indigenous populations, women, children, adolescents, older persons, persons with disabilities, and persons with HIV and other infectious diseases. Accessibility also implies the medical services and underlying determinants of health, such as safe, potable water, adequate sanitation facilities, and within the safe physical reach. Then accessibility has more dimensions. We'll not delve into that. We'll come to next is acceptability. All healthcare facilities and goods and services must be respectful of medical ethics and culturally appropriate, i.e., respectful of the culture of individuals, minorities, people and communities, sensitive to gender, life cycle requirements, as well as being designed to respect confidentiality and improve health status of those concerned. The confidentiality issue arose in Kerala, where some organization was desirous of accessing the data maintained by the state of Kerala, and the High Court of Kerala has struck down such access since the organization could not necessarily be monitored or fully trusted with maintaining the confidentiality of this data, as well as being culturally then the acceptability would also include quality, as well as being culturally acceptable. Health facilities, goods and services must be scientifically and medically appropriate and of good quality. This requires skilled medical personnel, scientifically approved, and use of unexpired drugs in hospital equipment and good hospital equipment, safe and potable water, and adequate sanitation. Again, there in fact are a large number of schemes of the central government. Now let us see what the central government has already done. There are in fact a large number of schemes of the central government towards securing the health of people in the country, mostly rural and some urban. There are hospitals in most districts and cities. These people, these are, however, grossly inadequate. The middle class are the worst hit. These people cannot afford private hospitals where the costs are absolutely prohibitive, and the facilities at government hospitals leaves much to be desired. Apart from the corruption and the facilities that are substandard, the medical and non-medical staff are disheartened, demoralized, or simply disinterested. The decisions referred to me are otherwise exceptions. The Supreme Court and the High Courts have held that healthcare is a right in getting at least the first aid in emergency situations from private clinics and hospitals, or access to public medical care in life-threatening situations, or to a healthy and safe environment and medical care for workers, etc. The orders, however, are not respected or followed in practice, other than maybe in the case of the particular litigant who has gone to court. The danger of spread of contagious diseases is a common factor haunting all nations. The present pandemic is a clear example of that. Without proper appropriate measures inter alia, that is a robust health infrastructure, people will suffer. One is reminded of Ruth Romer, an American lawyer and a public health campaigner, who writes, "The principal function of a constitutional provision for the right to health care is usually symbolic. It sets forth the intention of the government to protect the health of citizens. A statement of national policy alone is not sufficient to assure entitlement to health care. The right must be developed through specific statutes, programs, and services. But setting forth the right to health care in a constitution serves to inform the people that protection of their health is an official policy of the government and is reflected in the basic law of the land. Thus, social security, social insurance, decent standard of living, and public health ingrained in effective constitutional provisions and supported by international legal commitments must form the basis of the right to health care in India." This long discussion that we had by referring to international covenants, our constitutional provisions, the decisions of the Supreme Court and the High Courts, and the existing policies and decisions of the government would take us, puts a clear picture before us that healthcare must be viewed much, much more seriously than what is prevalent now in the constitutional and legal framework of this country. The legal and constitutional doctrine, mandate, and principle that is missing is the principle of justiciability. In the case of education, the 93rd Amendment to the Constitution has provided a limited justiciability. With regard to healthcare, there is even there is a much higher case made out for existence of enforceable rights, justiciable rights. Because more often than not, health is a question of life and death and or the quality of life itself. As stated earlier, for a small part of the working population, right to health care through social security, social insurance as a means exists. This means that such security can be made available to the general population too. If it is available to a small cross-section, it can be made available to the general public at large. What is needed is executive will in this regard. This means that such security, that a few people enjoy this privilege is also a sign of discrimination and inequity and violates not only international law, but our own Article 14 of the Constitution of India, which is the right to equality. International law provides many principles, but in India's case, there is substantial leeway within our own framework of laws on the right to health and healthcare. The emphasis needs to shift to address crucial mandate on the state as stipulated in the directive principles. This is the only way of bringing the right to health and healthcare on the national agenda, even as the support of international treaties will play some role in cementing this demand. So where is this all taking us? The state in the last 10 years has made some sincere efforts and attempts to address the need for healthcare by introducing schemes for addressing rural health concerns and some urban areas also. The efforts taken by the state in dealing with the pandemic must be commended, notwithstanding its shortcomings. However, it is felt that the measures undertaken by the state are more in the nature of a response to stimuli, as a biology student would understand, than a foresighted infrastructure-based approach. The conclusion that I wish to put forward before you is this: the shift in constitutional mandate and doctrine that is needed is for citizens to have the right to health and healthcare as a fundamental right, and not just an aspiratory right which is depending on the will and women fancy of the state. The current and is based on essential directive principles of state policy. The directive principles indicate the responsibility of the state, but it remains, the right to health still remains an aspiratory right. It has to move from a mere aspiration to a fundamental right which can be enforced, which can be justiciable, and every right that is flowing therefrom within the interpretation of the right to health as a fundamental right must be allowed to be enforced and must be enforceable and justiciable under Article 226 and Article 32 of the Constitution of India. The current pandemic has clearly emphasized this. The fundamental right to health would impose on the state not a mere directive to do charity, but a full-fledged fundamental and compulsive duty on the state to ensure all-round and comprehensive health care for the people. The issue can also be viewed from the predicament of the Supreme Court and the High Courts, as I was discussing earlier, in having to deal with all matters concerning health and medical rights, etc., under the omnibus umbrella of Article 21 of the Constitution. The decisions of the Supreme Court and international covenants and provisions, particularly the current pandemic, are a wake-up call to the nation, to the people, to the parliament, to all wings of the establishment of this country to recognize the right to health as a fundamental right. The need for this cannot be overemphasized. So these are my thoughts. These are my views. I sincerely hope that this would go some way in establishing a full-fledged, enforceable, justiciable right to medical facilities in India as a fundamental right, and not merely as an aspiratory right, or depending on what a particular executive at the relevant point of time would think it necessary, that in its wisdom is necessary, as opposed to what we can enforce as a fundamental right under Part 3 of the Constitution. Thank you. Thank you very much. Thank you, one and all.
Thank you very much, sir, for that enlightening and educating speech and dialect. So there are a lot of questions that have been arised, a lot of questions that have been asked, or students are asking, or attendees are asking in this round. So I would go ahead and ask a few questions on their behalf.
Please.
Yeah, thank you very much, sir. So the first question that has come is regarding people's trust in regarding health with the government is degrading. The principle of transparency and solidarity is being violated. Do you think the right to health must be shifted to concurrent list?
If it is a fundamental, see, the three lists that you have, that is the state, the center, the central list, and state list and the concurrent list, are those which enlist the powers of the respective the respective state and central governments and the jurisdictions they have to frame their laws. I was talking of something much higher than that. I was talking of this right to health to be raised to that of a fundamental right, and the responsibility to be given both to the state and central government to ensure effective medical facilities, which would be justiciable under Article 226 and 32. So, in answer to your question, I will say yes, it should be enforceable both against the state and the central government, and should form part of the concurrent list. But I do have one doubt in my mind always, at which is everybody's responsibility eventually ends up being nobody's responsibility.
Yes. Absolutely.
Yeah. Next.
The next question is, as right to health is implied under Article 21, despite the fact that our public health sector has not reached anywhere till this date from independence, how the poor strata of the society can have access to their health?
You see, there are two issues. One is provision of the facility and the right to have these facilities as an enforceable right. And the second part is the existing infrastructure of public healthcare that we have, and the inability of the government or the management of these hospitals to enforce discipline, to enforce transparency, to enforce freedom from corruption. If these are enforceability issues, we are talking of rights issues, and hence we have addressed the seminar from a fundamental rights point of view. When it comes to having the best of rights in this country, with the best of facilities, they are watered down when it comes to availing these benefits and facilities because of corruption, because of so many other issues, absence of transparency, and so many issues. Those are enforcement issues which have to be always looked at. So let us not confuse the two issues. One is existing facilities as they stand should be accessible, are meant to be accessible to one and all. But they don't permeate because of so many issues that I've already discussed now. The money sanctioned by the state and the center does not, in fact, get converted into, let's say, a good X-ray machine, functioning X-ray machine. The maintenance money for that X-ray machine is not used for its maintenance. It is somehow diverted or siphoned off. Then for the medication, which the Ranchi decision of the Supreme Court, they found that the mental hospital and every amount of money was being poured in by the state government and central government, whichever the government is. But it is not permeating to the people at large, because in the middle is incompetence, sometimes complete disillusionment of the staff, or disinterest of the staff, or corruption, or absence of transparency. Those are separate issues. They have to be enforced very strictly, and people should avail the facilities, and there should be more awareness spread by the government to avail these facilities. Next, please.
Thank you, sir. So another question is, do you think privatization of health sector alone can do a boom in health sector, as there are no laws regarding health specifically during the pandemic?
Now you see, our privatization experience in many sectors post 91 has substantially worked and has paid rich dividends for the economy. But insofar as health is concerned, public and private must coexist. Secondly, the government's investment in the public healthcare sector and advertisement, education, and strict monitoring of the public healthcare sector is extremely vital. So my answer to your question is, total privatization of the healthcare sector is not going to benefit a country like India. In the United States, without medical insurance, because most of the medical facilities are private, without medical insurance, you cannot even dream of buying a plate of food or dinner in the night. And basic food, we need medical insurance first. Which is why I gave the example of the National Health Service facility in the United Kingdom, where healthcare is completely free. But the flip side of the United Kingdom experience is that there are long waiting queues for getting a tooth removed or the tooth repaired. People therefore come to countries like India for getting, although the healthcare facility is free in the United Kingdom, they come to countries like India, Thailand, and Southeast Asia for getting small quick operations, because waiting process is long there. And the same experience you'll find in India, but that cannot in any way water down the need for and the importance of the National Health Service in the United Kingdom, and the need for a public health care to be made absolutely accessible and as good as free in this country.
So,
yes, please.
Thank you, sir. The next question that I have been asked is, India has rectified various health-related international conventions and has various legislations enacted. But the national picture of maternal health shows a grim picture. What suggestion can you give, sir?
As I have already said, first things first, there are facilities, there are public health hospitals, there are district hospitals, various districts in the country, there are primary healthcare centers, there are Anganwadi workers, there are Asha Karmis, Asha ladies who work for basic medical facilities and childbirth and things like that. There are midwives that are appointed by the government. But at the end of the day, to say that they are being effectively enforced, they are effectively permeating to the public at large, would not be correct. They are not permeating. Even there is corruption and interference by power blocks at various stages, and it is the well-connected and the well-endowed or powerful, richer people who have access, better access than the person who are more deserving. So my view is, to the existing healthcare structure is, if enforced correctly, if enforced in all sincerity, does substantially meet the need, but the enforceability is lacking, and would definitely get a fillip and a boost if it is made a fundamental right, in my understanding.
Thank you, sir. The next question that they have asked is, when saying healthcare and medical treatment, is it included alternative medicines as it is cost effective and easily accessible? Should judiciary take it in cognizance suo motu to direct government in this regard?
No. See, this is a very large debate. To what extent is judicial activism permissible? What is exclusively in the area of policy conceivement, policy making, is within the executive's exclusive domain and power. The power to make laws exclusively rests with the parliament. And I am rather orthodox in those views, but I am equally conscious of the real purpose behind judicial activism, which is in the area where there is executive will lacking, or maybe the executive has not addressed it for some reasons, and the parliament may not have passed any appropriate law. The judiciary should only indicate that these are areas where laws are necessary. We can only indicate as a judge from the High Court and the Supreme Court point of view. This is my personal view. But then if you look at the Vishaka guidelines, which was a watershed decision of the Supreme Court, that is, Vishaka was the state of Rajasthan, which brought into fore the basic guidelines of protection of women against sexual harassment at workplace, was an eye-opener for the entire country, and which led to the formal legislation being brought in by the parliament in this regard. So I would not, as a judge, venture out to decide what is good for the nation, whether it's allopathic Western medicine or our homeopathic medicine or the traditional Ayurveda. It is for the government to decide and for individuals to choose. As far as I know and understand, the Ayurveda is now being very seriously recognized by the government and various universities to be an alternative source for medicine, which is alternative to the allopathic medicine, and it has its own benefits.
Thank you, sir. Next question that has been asked is, government announced 50 lakh cover for health workers involved in the fight against COVID-19. Officials said that the 50 lakh cover is for accidental loss of life. Is this accidental loss of life? Accidental loss of life.
Accidental loss of life. Okay.
Is this accident insurance or life insurance then happens if health worker needs medical treatment? Financial Ministry had said the cover is for 3 months and the pandemic has reached beyond that point. Now what?
Gentlemen, these are again policy matters which a judge should not comment on. But I would say, given the fact that the health workers in this country have been in the absolute forefront in the fight against the pandemic, why only health workers? What about municipal workers? What about sanitation workers? What about the police force? They are all victims of COVID because of the active duty that they are engaged in for the purpose of managing this pandemic. According to me, their entire treatment should be taken care of by the organization concerned, by the government, and the concerned hospital, private or public, in which they are engaged, in which they are employed by or participating in, or on their behalf they are working against COVID. So my personal view is they should get a complete and comprehensive cover for treatment of health, for treatment of their condition, and in the event of a sad eventuality of their demise, they must be completely covered with appropriate amount of insurance. They have families behind them, their children behind them.
Thank you very much, sir. Another question that has come up is, people representative, unfortunately, are many a times unresponsive. Should
Please
people
come
have the
again.
right? People representatives, that means MPs and MLAs, unfortunately, many a times are unresponsive. Should people have the right to recall after a minimum time to bring into the accountability instead of fixed term of 5 years? How
I
can
think this question would call for another area and subject of discussion. It should not be addressed in this semi-webinar.
Okay.
Yes, yes. I also feel the same. I think please keep up that question, Mr.
Please come to the
Vardhaman.
next question.
Next question, next. Yes.
Okay, okay, sure. So, I think,
That's all?
the remaining.
sir, one last question I would
Yeah.
go through. Is there any law or regulation regarding format and maintenance of case sheets in India, like Medical Records Act? Is it not absence of such a standardization also responsible for this situation?
See, there are most likely there's no law mandating such requirement, but there are other establishment-based laws that require maintenance of medical records, and records of all patients coming in and going out, and by birth, death, that are interlinked with the functioning of the established infrastructure for medical care. These are, along with municipal records. For example, a birth certificate is generally issued by the local municipal corporation or the panchayat, but it has to be based on some hospital record, or a document or some issue by the midwife or the concerned panchayat where there are no hospitals. The Gram Panchayat Pradhan or the himself or herself will have to certify. So I do agree that there should be an appropriate regulatory law or code or rules in this regard to have some statutory force which would compel the hospitals and organizations to have these records.
Thank you very much, sir. Thank you for enlightening us. Thank you for answering so many questions. And now I would like to ask Shrikant, Mr. N. Shrikant, to take on the stage.
Thank you, Vardhaman, sir. Honorable Justice Sri Rajsekhar Mantha Garu, respected Professor Anita Rao Madam, Director GITAM School of Law, my dear colleagues and participants, I am very much thankful to you for giving me this privilege to propose a vote of thanks. I, on behalf of GITAM School of Law, I would like to express our sincere thanks to Honorable Justice Rajsekhar Mantha Garu for giving an excellent coverage on today's topic and giving an overview of various international covenants, conventions, and also constitutional provisions such as fundamental rights, directive principles of state policies with case laws. And also, Honorable Justice very well explained about the Constitution, how the Constitution should be adopted to the various crises of human affairs, what now presently we are facing in form of COVID-19. And also, Honorable Justice very well explained the role and responsibilities of government, private medical hospitals, and lastly, accessibility, acceptability, and enforceability of right to health as a fundamental right. Thank you very much, sir.
Sir, before we wind up, sir, let me submit myself my heartfelt thanks to you for sparing such valuable time of yours, being Sunday. I know how you busy you are, because tomorrow being again the working day for you, and prepare such wonderful real research work, no less than a research document, and you have given us huge amounts of in-depth of knowledge on this particular topic, right to health. Especially it is highly relevant at this particular pandemic scenario. There are so many doctors here as attendees, who are actually taking your advice, and they must be really feeling great listening your lecture. Very rightly, I would like to say, sir, you have given a great model, which has been adopted by US, keeping a real contingent in case of disasters like this, that will definitely, come in hand without, hurrying up where the state will do or center will do. So it is the common responsibility of both state and center. If at all we really make it as a fundamental right, we need not wait. So as a matter of right, not as a matter of privilege, every citizen of this country can claim and demand and enjoy his life to the fullest extent. Thank you very much, sir. In fact, I would like to extend my thanks to Dr. Umarao, who was consistently, coordinating with this. I thank her very much for their wonderful coordination, and also our faculty members, and also especially all those attendees who came here honoring our words. Thank you so much, sir. And it's a great pleasure being with you today on a Sunday. Thank you.
Thank you.
Thank you, sir.
Thank you everyone for attending this webinar on on this topic. And I would request all of you to click on the link form that has been shared. I think it is not.
I think Vardhaman, you can also announce, because a lot of questions are coming, that about this e-certificate. Please tell them whoever fill up these feedback forms will definitely get their certificates through mail. And of course, the photo, somebody wanted it with the certificate, it cannot be arranged this time. Probably next time we will do that. And I know whatever the questions are not answered or not been announced, probably we can send them a mail clarifying their doubts. Thank you, Vardhaman. Thank you, Srikanth, too.
Thank you very much, ma'am.
Thank you.
Okay, all the attendees can click on the link and please fill the form so that we can have your mail IDs and your names for the e-certificates. And after you have submitted the forms, we'll be sending the e-certificate within 1 or 2 days. Thank you very much for attending. Have a nice day. Bye.
Can I leave, Vardhaman?
Yes, sure.
Thank you. Thank you so much. Thank you for wonderful coordination. Both of you, rather.
Feedback link. I've just posted in the chat. Please see the chat. I've just posted the link. Please fill up the feedback form and please give us your reviews. And please can't open the link, sir. Please, this is the link for the feedback form. Please write down your reviews and please submit your feedbacks on this form. And this will be the form that will be used for sending the certificates. Please write the correct name and your correct mail ID. If you do not write your correct mail ID, you will not be able to send the form e-certificates to your mail ID. So please be aware of that.